Anyway, we're moving on now to another of our so-called masterclasses. As you know, what has taken up a lot of activity of EU Disinfo over this last year, and perhaps even before that, is work, advocacy work on the EU Digital Services Act, which of course is now finished with the legislature, but that doesn't mean it's finished in terms of implementation, enforcement, and sorting out all the wrinkles in how it works. And of course, it's a hugely big deal for how we deal with disinformation going forward. Now, it gives me great pleasure to introduce you to another member of the EU Disinfo team, one of our newer members. So I'm going to welcome Rita Jonusaite, who works for us as Advocacy Coordinator. She previously worked for the European Youth Forum as Policy and Advocacy Manager, and before that for the Foreign Ministry in Lithuania. So welcome, Rita. We're really proud to have you with us. And go tell us all about
Can you hear me? All good? Let me just check that it works. It's a big button, right? This is why I'm not the one in the office dealing with IT, and Alex takes care of it. I'm not the greatest at it. I'm very happy today to be able to bring you this presentation. I do think this is very important. I hope you too, and you're looking forward to hear what we are having to tell you. I actually tried to count how many times the Digital Services Act has been mentioned throughout the last 2 days. So I think the question whether it is or isn't important for our community is not even there anymore. And what I will try to do today is first to sort of make sure that everybody understands what we are talking about when we are talking about Digital Services Act, that nobody is lost in the room. Some of you have been engaging with the process and overseeing what's happening throughout the last 1.5 to 2 years. Some of you probably are quite new, but the Digital Services Act, as Jana just said, has been adopted. You'll hear about it a bit later, and it's here to stay, and it is really impactful. So it's good if you all understand it. I'll try to dive deep into what are the most important provisions in the Digital Services Act for all of you when it comes to disinformation, and how best we can use the rights that it gives to us. I'll try as much as I can to get out of my EU bubble and shape it in a way, again, that we understand what is important. And I'll give the updates in terms of what are the next steps, and I'll try also to pinpoint the attention points where we would like to see the community engaging a bit more actively. So what is the Digital Services Act, or the DSA in short? It is a groundbreaking law when it comes to internet safety and platform accountability. With this regulation, platforms will be much more accountable for their role in disseminating myth and disinformation, providing access to data, as it was mentioned, and a lot of other provisions. But what is important to point out as well is that the Digital Services Act applies to a number of digital services. You probably mainly heard that indeed it will be important for the biggest players such as Meta, such as Twitter, Google, but it will cover a lot of platforms, also hosting services, and even internet service providers. Though the most important obligations indeed will be directed towards very large players, so very large online platforms and search engines. I wanted to debunk one of the myths of my own that I discovered when working on the DSA, that indeed it's not only about illegal content. The DSA is looking at harmful content so as to harmful but legal content such as disinformation, through societal risks, and also as in how platforms deal with violations of their terms and conditions, which would also then cover disinformation. I'm not gonna give you the pain and going through all the process, not gonna do that. What I wanted to say is that indeed, the law has been adopted. It actually was signed last week by the Council and by the Parliament, and the rumor has it that it should be officially published tomorrow. So you hear it today, and then you can double check everything what I said today, tomorrow when the official text is out. And I'm also not gonna just go by the articles. I'll try to phrase it in a way that, in terms of the content. What is probably one of the most important things when thinking about user rights in the DSA is internal complaint handling system. And we have been working really hard during the negotiations process to make sure that the users would be able to submit a complaint not only when the content has been removed and they think that it was, there was a mistake unjustifiably, but also when you, let's say as people working on disinformation, have noticed a piece of disinformation, flagged it to the platform and nothing has been done. So basically making sure that a decision not to act is also seen as a content moderation decision and can be challenged. I don't know how many of you flagged content to platforms and nothing happened. You can raise a hand just to show how much of a problem it is. Yes, it is a big problem. Essentially, if implemented right, of course it depends how user-friendly the tool is, it would help many, many of you to address that. And in case a platform comes back to you saying, I still believe that the content that you flagged should not be should not be removed, there are other provisions in the DSA that allow you to challenge it once more. This is what is called out-of-court dispute settlement body. This body essentially is a third sort of entity that would bring together you as a user and a platform, and then sort of reanalyze the decision of a platform not to remove a content or to remove a content depending on a claim. Why is it important for you? It's because in most member states, disinformation is not illegal, you know that. So essentially, you normally don't have, in most cases, an opportunity to go and discuss in front of a court. So this is giving you another mechanism if you can't go to the court and sort of challenge the platform there. Another thing, what we think is very important in the DSA is a representation article. Essentially, it gives an opportunity for an organization to represent a user in defending his or her rights. So, and that specifically applies to the other two articles that I just mentioned. So essentially, you yourself could become that organization and represent people working on disinformation, or you could ask an organization that obtained that status to represent your rights. I'm moving forward. One more thing that you probably will hear quite a lot, and you heard a bit already in these days, is the access to data that the DSA is giving to researchers, and that's what I wanted to flag. There are many other articles, and that's why linked to data, and that's why I called this slide the data generating machine. There will be a lot of data coming from the DSA. This is the whole notion of transparency in terms of what happens with content moderation practices, how many appeals the platform received, what did they do with claims and notifications that were submitted, and all of that kind of information that is very important. But the access to data indeed is going to be the key. And what I wanted sort of, as I said, I'll give some kind of pointers, what is important for the future. The upcoming delegated act for the access to data is going to be key. Because it will define the details, how this access to data is actually going to look like and what kind of data you will be able to access. And here important is that normally in a process, and that's still quite some time ahead, there should be a public consultation. And our understanding is that the Commission specifically, who's going to be working on the Delegated Acts, would be interested to hear from the community what are the challenges normally that you face when accessing data, when researching platforms, and how the provisions that we're going to put forward in terms of creating this framework, how to access data, could actually be addressed. So here, and we are very happy in the future to sort of flag this to the community and facilitate that input, would encourage as much as possible to engage and to share that experience, that essentially we could have a framework that works for those who are researching platforms. Another couple of things that I wanted to mention. So for the very large players, very large online platforms and search engines, they will need to do risk assessments and risk mitigation measures. When it comes to risk assessments, we will need to look how the services that we provide contribute to such societal risks as disinformation. And here is important for you because essentially, while it's not mandatory, platforms should engage to an extent community in defining what are these systemic risks and what mitigation measures are going to be taken. And here as well, my understanding is that the institutions who are going to be overseeing how platforms are dealing with this would like to hear from the community if you were, to an extent, somehow involved in that process and consulted and able to provide your input. When it comes to practicalities as well, independent audits in the DSA will be very important. It's still to be defined how it's going to be done, and that's key, because when the auditing framework is going to be designed, that's going to, if it's a good framework, it's going to show where the platforms fail in complying with the legislation. So setting up the right framework will be a key thing in the coming months and year to make sure that we understand what's going wrong on the platforms and are able to challenge it. And about challenging it, so there is a piece of legislation, it's a very nice piece of document, right? That's it, how it's going to be enforced, how it's going to be implemented. When it comes to enforcement of the DSA, there are two key aspects. There is the European Commission that's going to be responsible for the enforcement of the DSA towards very large online platforms and search engines. And then there are digital service coordinators in member states, so essentially national regulators. So they're going to be looking how the platforms, how those who are subject to the regulation are actually implementing it. The most important for us in the coming months and years is going to be understanding how this works in member states. And while, at the EU DisinfoLab, I think we have a very big ambition always to do as much as we can. We are not that many. We are not in 27 member states. Here, the support of a community as well is going to be essential. We want to hear from you as the time goes. If you are in touch with your national regulators, how do you think they are working? What are the key issues? Who are performing best? And maybe some of these practices can be replicated, but because also some of these things we could be able to flag on the European level. So here, the cooperation is going to be key. And my email address, I'm sure, is on the website, so just drop an email, whatever you hear, what's happening in your member states. Yes, the code of practice on disinformation was mentioned in previous presentations as well, so I'm not going to spend too much time on this, but the key thing, it will The Commission intends to have it as a co-regulatory mechanism between the DSA and the Code of Practice on Disinformation for very large online platforms and search engines. What it means in practice, it means that these stakeholders would be able to say, okay, we identify a systemic risk that our services contribute to disinformation, and the way to tackle is signing up to the Code of Practice on Disinformation. What is good in the DSA, it does say that just signing up to the Code of Practice on Disinformation is not merely sufficient to say, I tackled the risk, you also need to implement it. So essentially, it makes sure that the very large online platforms and search engines signing up to the Code of Practice on Disinformation as a mitigation risk have to properly implement it. Otherwise, if after the auditing process it says, no, you're not complying with your responsibilities under that, what potentially can happen? Infringement procedure and then the fines. In reality, these are the processes that would probably take quite some time, and we need to see how it actually practically works, but that's the idea. One thing that we also wanted to mention in terms of a media exemption, you heard about it if you attended the last conference, you have seen probably a lot in our communications. We are very happy to say, indeed, the media exemption in the DSA has been rejected at the beginning of this year in the plenary vote. And I think here it's important to take a moment to thank you all who contributed to that. It wasn't really only EU DisinfoLab's achievement. It's an achievement of the community, the support that you gave us by signing letters, by talking to your ministries, contacts in the Commission, in the Parliament. That was a big, big community effort here in Brussels, but much beyond that. So I think maybe there is an applause for everybody in the room for all the work that you did. But the story is not over, unfortunately. Probably you heard mentioning the Media Freedom Act that has been put on a table by the Commission this September. Here in the Media Freedom Act, there is a specific article on the content of media service providers on very large online platforms. It has a dangerous proposal with a kind of an ex-ante notification mechanism that essentially opens the door for further lobbying on media exemption as the legislative process goes down. So we are actively monitoring it and engaging and raising awareness. The key thing is, as much as support we had from the community for the DSA, we very much might need that kind of support, working on trying to avoid having this disastrous media exemption in the Media Freedom Act. So this is a bit of a heads up. You might receive calls for action and outreach, and very much hope that we can continue relying on the support that the community has provided so far on this matter. I said I'm going to make a lot of points of attention, so if something... and yeah, when it comes to the next steps, I wanted just to briefly and quickly elaborate what is upcoming in terms... Yes, indeed, the legislative process as such has ended. As I said, most likely tomorrow the official text is going to be available. And since 20 days since then, it enters into force. What it means in practice, it doesn't mean that it starts applying to the platforms right away. Actually, no. But the Commission as such gets quite a lot of powers already in terms of being able to ask information, inquiries, etc., etc. When it comes to platforms, it enters into force for very large online platforms and search engines 4 months after, it applies 4 months after it enters into force. And when it comes to practical things, it means that after they're going to be designated, so named as very large online platforms and search engines, most likely already by summer, they should be submitting first risk assessments to the Commission. And then following that, risk mitigation measures, et cetera, et cetera. So that's where, again, keep an eye on the fact that normally the platforms could reach out to the community asking for input, and again, the Commission would be potentially interested to hear if that ever happened or not. And then the law enters into force for everybody else in the first quarter of 2024. Yes, so that's the meme that I designed. I'm very proud of it. I hope you like it too. Again, getting back to the thing that a law on paper is one thing. The next thing is how we implement it. There has been quite a lot of criticism in terms of similar laws in terms of the size and importance, how the implementation went. Specifically, I'm mentioning here GDPR. There were some mistakes made. I think there were quite a lot of lessons to be learned from that. And we need to make sure that when it comes to the DSA, for it actually to have the impact that it's meant to have, that it's really well enforced and the platforms are accountable. And that's a work of regulators, the work of the platforms who are subject to the regulation, but also the work of the community to help that to happen. And I'm done. Unless you have questions, of course.
Sorry. Andrei Tiot, Global Focus Romania. One of the surprises that I had in the debates about the DSA was that the online platforms were relatively okay with that. There were less pushback than I expected. And my personal theory is that they plan to delegate the work to algorithms. My understanding is that there is not necessarily an amount of effort that is specified through the Act. And this leads my question specifically to Article 20. Are there any kind of quality standards there? Or if you want to play it badly, can you just make an algorithm, say that you work on the algorithm, and generally invest very little effort? Because between Article 20 and Article 21, there's quite a big gap for the user. Article 20 is easy to follow, but I suppose that the 21 article about out-of-court dispute is much more complicated. And there could be a strategy where you just work very little on Article 20. Would that be possible under the current regulation, in your opinion?
It's a very good question, and it has been touched upon during the negotiation process. So if you read the Article 20, it specifically says that appeals should not be covered only by the automatic tools. So specifically, the fact that human oversight has to be involved has been put in place. So essentially not to be able to game it, because it also wouldn't make sense. Imagine if the content moderation mistake, so to say, has happened because of the algorithm. If that's left only for algorithms, they would probably make the same assessment, right? So you're not having this, indeed, the quality check. Yes. Specific provisions in the article.
Hi, Christian from the EUI. A question I have is, what kind of support can member state, like censors who are going to enforce this, expect from the EU? Because some of them are either extremely understaffed, underpaid, a small budget, or don't really have the capabilities to do what you guys want them to do. Are there any support from that?
For digital service coordinators, right?
Yeah.
Essentially. Yes, that's going to be a challenge. Unfortunately, in the EU budget specifically, there is nothing foreseen to support digital service coordinators. It's really up to member states to figure out how to make it work properly and get resources for that. There could be different schemes for this, but it is going to be definitely a challenge. Look, it's a challenge already on European level for the Commission to be well equipped and have enough resources to be able to enforce the law on very big players. It's the same going to be in member states. Unfortunately, in some member states, I think it's going to be even worse. I think, on the other hand, it's also a political decisions that member states have to make, putting it as a priority in order to have safe online space. You need to invest in that. It's a political decision.
Thank you. Sorry, I come from Romania, civil society. Have we thought about the situation where, it's not like in Western Europe or US, where you can assume you have some benevolent governments, and whenever you have a problem, you try to solve it together with them. But this is an exception, on the planet. We come from Eastern Europe, and my life experience tells me whenever you create an instrument, it's more likely than not that the governments will use it using the letter against the spirit, which they constantly do with many European directives. I'm talking about the new member states. And there's huge potential with these instruments which are created in good faith, and we negotiate it in this space here in Brussels, in Western Europe, and when they are transposed there, the very first moment they will be deployed to take out, with the cooperation of platforms, people who are not coordinated to stay there, or liberal voices, or people who displease the governments. They are very skilled and they have resources, and there are precedents for that. This is the problem. There are precedents, and not just in online or technology, in many, many, many respects. Take EU regulations, take the letter and use it completely against the spirit. Have we thought, and when there were negotiations and we were represented by our elected representatives, of course they will not say this in negotiations, because they long for such instruments, actually, to silence uncomfortable voices in society. So I'm not really sure this trade-off is where it should be for those societies. It looks relatively okay here.
That's a very good comment. Maybe first, so it's a regulation, not a directive, so it's not going to be a transposition, meaning that there is less room for interpretation in terms of what to do with the law. The worry that you're expressing, it's there. I also heard people at the Commission, at the Parliament, mentioning the potential abuse of these mechanisms. That's why when it comes to digital service coordinators, there is a specific provision in the DSA saying we should be politically and financially independent. There are other ways how to tackle it. For example, you would have a European board of digital service coordinators that brings together digital service coordinators of member states, and for example, 3 digital service coordinators from different member states would be able to launch inquiries into, for example, why the digital service coordinator of a certain country is not looking into certain things, what platforms doing or not doing in their country. So there were attempts to put down certain safeguards, but obviously the risk is always there and everybody is acknowledging it. The question is then, for example, if the Commission would be then keen doing something about it, bringing certain cases in front of a court of of a court of justice and things like that. That's a bit out of our hands either. we are done, as far as I understand from Alex.
I know that Rita is wonderful, but we've got to get to the break. So give her a big thank you, and you can catch her over the break. Well done.